Reading the intro of the Servicemember Civil Relief Act, starting with page 224 of the old text, 243 of the PDF. The Servicemember Civil Relief Act, originally titled the Soldiers and Sailors Civil Relief Act, was first enacted by Congress in 1918. Its purpose is to protect military service members from civil action while they are on active duty. While this law, in its present form, dates back to World War I, it has roots in laws enacted during the Civil War. In 1918, Congress passed a law preventing repossession and foreclosure on property of military personnel serving in World War I. The 1918 law expired in 1940. In 1940, Congress reimposed it immediately before World War II. The public policy purpose for this law is to enable men and women in the armed services to devote their entire energies to the defense needs of the nation by relieving them from the distraction of civil matters. The civil matters covered by the law include lease agreements, lawsuits, loan obligations, and insurance contracts. The conflict in the Persian Gulf in 1990 to 91 prompted Congress to update this law. It was substantially revised and renamed the Servicemembers Civil Relief Act in 2003. The National Defense Authorization Act for fiscal year 2006 added a requirement that a notice be drafted by HUD to be provided to service members obtaining a home loan explaining the mortgage and foreclosure rights of the SDRA. In 2007, in accordance with the John Warner National Defense Authorization Act, the Department of Defense issued regulations to govern extensions of consumer credit to service members and their dependents. This regulation is part of the Department of Defense's social compact with members of the active military to help maintain their quality of life. It regulates the amount of charges that may be associated with a covered loan, mandates certain disclosures at the inception of the loan, and sets forth other limitations on these loans. Since financial stress rated highly in a survey among active service members, the restrictions in the foreclosure are an attempt to reach a goal of maintaining mission readiness among the active military by reducing financial stress. The Housing and Economic Recovery Act of 2008 extended the foreclosure protections for service members to 9 months after the end of their active duty. The Higher Education Opportunity Act, enacted in 2008, made the SDRA interest rate cap provisions applicable to student loans. For information about homeownership counseling requirements for service members, see Homeownership Counseling. In 2012, the Honoring Americans, Veterans, and Caring for Camp Lejeune Families Act extended the foreclosure protections from 9 months to 1 year. Subpart 1, Service Member Civil Relief Act coverage. The term service member includes persons on active duty in the federal military service, including members of the Army of the United States Navy, Marine Corps, Air Force, Coast Guard, and all commissioned officers on active service with the Public Health Service or National Oceanic and Atmospheric Administration. Citizens of the United States on active duty in the forces of a nation with which the United States is allied in the prosecution of a war or military action are entitled to the relief and protections under the SDRA. Dependents of the service member are covered by some protections. When applicable, a dependent includes the service member's spouse, child, and any individual for which the service member provided at least one half of their support during 180 days preceding the application for relief under this act. The SDRA applies to any civil, judicial, or administrative proceeding in a court or agency subject to the jurisdiction of the United States. Service members who qualify for the protections of the law may waive any right or protection afforded by the act. The waiver must be executed either while the service member is on active duty or after he or she receives orders to active duty, and it must be in writing if it pertains to a modification, termination, or cancellation of a lease, contract, or obligation secured by a mortgage deed or lien, or it relates to a repossession, retention, foreclosure, sale, forfeiture, or taking possession of property that is security for an obligation purchased under contract, lease, or bailment. Letter B, requirements and general requirements, is where I left